Hello and welcome everybody to the Navigate AIF Study With Me series. In this video, we will discuss the recent SEBI circular released on 19th August 2024 on the topic of the modalities for migration of venture capital funds. These are funds registered under the SEBI Venture Capital Funds Regulations in 1996 to the SEBI Alternative Investment Fund Regulation 2012. Let me give you some perspective into why this circular was introduced and what is the reason behind it. So the failure of AIFs and VCFs to wrap up their operations, liquidate investments and wind up within the time frame set forth in the PPM has been a cause of concern for SEBI in recent times. In fact, SEBI has even passed two significant orders on this issue. These are the orders in the case of Urban Infrastructure Venture Capital Fund on 31st October 2022 and the Vistar Religare Media Fund order on 24th April 2023. SEBI has emphasized in these orders that VCFs have a defined lifespan and must be wound up upon the expiration of their tenure. SEBI highlighted that the investment manager does not possess the authority to extend the fund's tenure by bypassing the provisions of the AIF regulations. Also, SEBI itself lacks the jurisdiction to permit extensions of tenure by easing the stipulations under the AIF regulations. So while the fund documents outline a specific tenure of the fund and a discretionary extension period, these are established based on the average life cycle of an investment in the proposed investment sector or strategy of the fund. However, what has been observed practically is that there are a lot of difficulties that are faced by AIFs and VCFs in liquidating their investments. So what is the main cause for these difficulties? The first one was litigation challenges. A primary concern emerges when the assets held by AIFs and VCFs become ensnared in legal disputes. In these cases, the process of winding up had become very delayed. Now, what SEBI had done in response to these issues that were faced by AIFs and VCFs was that they launched the concept of a liquidation scheme. So what is a liquidation scheme? A liquidation scheme operates as a close-ended scheme initiated solely by an AIF for the purpose of liquidating their unliquidated investments acquired from its scheme after its tenure has ended. The AIF regulations actually stipulate a 1-year period called the liquidation period that is still there in the regulations, and in this 1-year period, the manager is required to liquidate all the investments in the fund. And the liquidation scheme was to be launched within this liquidation period. However, there's one important thing in the concept of liquidation scheme, which is that the option for liquidation scheme was only applicable to AIFs which were in the liquidation period. So it was not applicable to AIFs which were beyond the liquidation period, and also importantly not applicable for VCFs. So this circular actually provides an option to VCFs who still have unliquidated investments and have not been able to wind up their operations. So let's look at the circular and look at what SEBI has prescribed in greater detail. So here's the circular, 19th August 2024. This is the topic. SEBI AIF regulations have been amended and notified on 20th July 2024 to provide flexibility to VCFs registered under the erstwhile VCF Regulations 1996 for migrating to AIF regulations, and to inter alia avail the facility of dealing with unliquidated investments of their schemes upon expiry of their tenure. A copy of this notification is also available at the link, so you can look at the amendments that have taken place in the SEBI AIF regulations to facilitate this. In terms of Regulations 19V1 of the AIF regulations, migrated venture capital fund means a fund that was previously registered as a venture capital fund under the VCF regulations and subsequently registered under the AIF regulations as a subcategory of venture capital fund under category 1 AIF in accordance with the provisions of chapter 13D of the AIF regulations. So let's look at what is chapter 13D in the AIF regulations. I have highlighted this for your reference. For the purpose of this chapter, unless the context otherwise requires, the terms defined herein shall bear the meanings assigned to them below, and the cognate expressions and variations shall be construed accordingly. So this chapter firstly defines what is a migrated venture capital fund, and this is the definition that we just read. It also defines investable funds, which means corpus of the scheme of the migrated venture capital fund, net of the expenditure for administration and management of the fund. In terms of Regulation 19X1 of the AIF regulations, an application for seeking registration as a migrated venture capital fund shall be made to SEBI in the manner specified by SEBI. In this regard, while applying to SEBI for migration to AIF regulations, As migrated VCFs, the VCFs must submit the following. First, original certificate of registration issued under the VCF regulations, requisite information as per the format specified in Annexure 1. So these two things have to be provided. Let's see what is the requisite information provided in Annexure 1. So I'll just search for that. Okay. So Annexure 1 provides the information to be filed with SEBI by VCFs registered under the VCF regulations for the purpose of migration to the AIF regulations as migrated VCFs. So there are details with respect to VCF and its trustee, manager, sponsors applicable. You can see the general information about the name of the applicant, PAN, registration number, office address, correspondence address. I'd say it's very, very similar to the Form A that is generally filed for an AIF, which is looking to obtain registration from SEBI. You have details of the trustee company, how it's registered, detail of the sponsor, details of the manager, whether the manager is registered with the board, any other regulatory authority, details pertaining to the scheme of the VCF. Now this information has to be submitted separately for each scheme of the VCF. So for every scheme that the VCF has launched, you have to provide this copy of the PPM, date of initial closing, final closing, tenure, extension of tenure, end date of the tenure, end of liquidation period, residual tenure, amount of commitment raised, amount of fund raised, cumulative investments made, a lot of financial information, whether the scheme has investment of net of not less than 5 lakh rupees of each investor, whether the scheme has a firm commitment from the investor for contribution of an amount not below rupees 5 crores before the start of VCF regulations. Then declaration with respect to details of regulatory actions. You have to give a declaration that there are no pending investor complaints, etc. To give a declaration that the trustee, the sponsor, manager, etc. are not involved in any litigation connected with the securities market and no order has been passed against them for violation of securities laws. Whether the applicant, trustee, sponsor, manager or its directors, partners are or have been involved in any litigation connected with the securities market which may have an adverse bearing on the business of the applicant. So same as your Form A. I'd say very, very similar information and declarations are required here. You have to again give this, whether they have been refused a certificate by SEBI, fit and proper criteria. So same as Form A, you have to also give a declaration statement here that you agree that the information supplied is true. You agree that you will notify SEBI if there's any change in this information. You agree that you will comply with the AIF regulations and Government of India guidelines. You agree that as a condition of registration, you will abide by operational instructions and directives that have been issued by SEBI. So very standard kind of form that is also filed by AIFs when they are applying for registration. While opting for migration to AIF regulations, VCFs having only schemes whose liquidation period in terms of regulation 24(2) of the VCF regulations has not expired shall be subject to the following conditions. Firstly, the facility of migration to VCF AIF regulations shall be available till 19 July 2025. Now this is important. This is the deadline that has been prescribed by SEBI, and if you are a VCF whose schemes are only in liquidation period or your liquidation period has not yet expired, then you have a timeline till 19 July. The tenure of the schemes of migrated VCF upon migration shall be determined in the following manner. In case a definite tenure was disclosed in the PPM of the scheme under VCF regulations, such scheme shall continue with the same tenure upon migration. In case a definite tenure was not disclosed in the PPM, the residual tenure of the schemes of the migrated VCF shall be determined prior to the application for migration with the approval of 75% of investors the value of their investment in the scheme. So these are the two possibilities that are there, and this is only for VCFs having only schemes whose liquidation period has not expired. Now while opting for migration to AIF regulations, VCFs having at least one scheme which has not been wound up post expiry of its liquidation period. So liquidation period has expired, you are now beyond the term and you still haven't wound up your scheme. Now this is what's applicable for you. Such VCFs may apply for registration, again same deadline, 19 July 2025, only if the VCF or any of its scheme do not have any pending investor complaint with regard to non-receipt of funds or securities as on date of the application. So what happens to those VCFs which have any pending investor complaints is something that has not been prescribed by SEBI. So my analysis from this is that if you are a VCF where you have not yet wound up beyond a liquidation period and you have a pending investor complaint, you have a strong deadline of less than a year to make sure that you resolve this because otherwise you will be in deep trouble because you'll not be able to migrate to the AIF regulations. And if you don't migrate to the AIF regulations, SEBI has said they'll penalize you and they'll take action, etc. In terms of Regulation 19 AF4 of the AIF regulations, a one-time additional liquidation period of 1 year from the date of notification of amendment of the AIF regulation, that is a period until 19 July 2025, because the amendment of AIF regulation came in on 19 July 2024. So you have a one-time additional liquidation period of 1 year till 19 July 2025 shall be available to the scheme of the migrated VCF whose liquidation period has expired and is not wound up. Let's look at 19 AF4 as well. Here's 19 AF4 or 19 AF1. So let's see 19 AF, the whole regulation. The tenure of migrated venture capital fund shall be calculated in a manner as may be specified by the board. So we have to look at the circular for how to calculate the tenure. Extension of the tenure of a migrated venture capital fund may be permitted for up to 2 years, subject to the approval of 2/3 of the unit holders by value of their investment in the migrated venture capital fund. So again, you are allowed to extend for 2 years with the approval of 2/3. This is the same as is given for AIFs, like close-ended AIFs. So they are also allowed to extend the tenure up to 2 years with 2/3 unit holder consent. In the absence of consent of unit holders under sub-regulation 2 or upon expiry of the extended tenure, the migrated VCF or the scheme of the migrated VCF shall be wound up in accordance with Regulation 29. So if you have extended the tenure, you've got the consent, you're beyond that, you have to make sure you wind up. So that's a hard stop from SEBI. Provided that sub-regulation 9A of Regulation 29 shall not be applicable to migrated VCF or the scheme of the migrated VCF. So what is Regulation 9A? So this is Regulation 9A of Regulation 29. It says if the liquidation period of the scheme of the AIF has expired or is expiring within 3 months from the date of notification of the AIF regulations, second amendment regulations, such schemes may be granted an additional liquidation period subject to the terms and conditions that may be specified by SEBI. Provided that the additional liquidation period granted under sub-regulation 9A shall be without prejudice to the issuance of any direction or measures in accordance with the provisions of the Act and regulations framed thereunder. Okay. So importantly, sub-regulation 9A is not applicable to VCFs, migrated venture capital funds. If the assets of the scheme of a venture capital fund registered under the VCF regulations are not liquidated after the expiry of its tenure in terms of sub-regulation 2 of Regulation 24 of VCF regulations, prior to the date of application for registration under this chapter, and the VCF has been granted registration as a migrated VCF under these regulations, then the schemes of the migrated VCF may be granted additional liquidation period subject to the conditions by SEBI. So SEBI had said there that 1 year you will get. So who gets 1 year additional liquidation period? VCFs having at least one scheme which have not been wound up post the expiry of its liquidation period. Provided that the registration as a migrated VCF granted under Regulation 19X of these regulations and the additional liquidation period granted under sub-regulation 4 of this regulation shall be without prejudice to the issuance of any directions or measures in accordance with the provisions of the Act and regulations framed thereunder. Okay. If the VCF also has schemes other than schemes stated in para 5.2 above, so if there are schemes other than the scheme stated here, that is schemes whose liquidation period has not expired, the tenure of the schemes shall be determined as per the provisions of para 4.2, which is the tenure will be calculated upon migration as if there's a definite tenure in the PPM, then you continue with that. If it's not disclosed, then you get investor consent for calculating a tenure. Upon migration to the AIF regulations, the investors onboarded, investments held, and units issued by the VCF or schemes of the VCF registered under the VCF regulations shall be deemed to be part of the that of the migrated VCF or its scheme under the AIF regulation. So basically, all of your VCF schemes, your investments in VCF, all your investors who have come in VCF now are migrated VCF under AIF regulation. So AIF regulation is applicable on them. And to give additional clarity on what is the legal regulatory framework applicable to the migrated VCF, the next para is very important, where SEBI says that the applicability of the provisions of the Master Circular dated May 7, 2024 and other circulars subsequently issued under the AIF regulations to migrated VCFs are given in Annexure 2. So let's see what is Annexure 2 saying. So Annexure 2 has actually provided which all chapters of the Master Circular are applicable or inapplicable to migrated VCFs. What I have done for your reference is that I have actually created a master circular file where I have highlighted the chapters which are applicable and which are not applicable. So this is the file. Whatever are applicable are highlighted in yellow and what are not applicable are highlighted in pink. So you can see easily which chapters are highlighted, which chapters are applicable and which chapters are not applicable. And you can use this for your reference if you are a migrated VCF. I will make sure that I share this on my LinkedIn so that anybody who needs it can access it. Going back to the circular, to the next point. Further, with respect to VCFs registered under the VCF regulations that do not opt for migration to the AIF regulations, the following is specified. Schemes of VCFs whose liquidation period has not expired shall be subject to enhanced regulatory reporting as may be prescribed by SEBI in line with the regulatory reporting applicable to AIFs under the AIF regulations. So if your liquidation period has not expired, you have to report whatever AIFs are required to report. VCFs having at least one scheme whose liquidation period in terms of regulation 24(2) of the VCF regulations has expired shall be subject to appropriate regulatory action for continuing beyond the expiry of the original liquidation period. So if you don't opt for migration and you have a scheme whose liquidation period has expired, be ready for regulatory action by SEBI. So basically SEBI is saying make sure you do this, otherwise we are coming after you. The flexibility to opt for migration to AIF regulations shall not be available to VCFs wherein all the schemes have been wound up and or no investment has been made by the scheme of VCFs which have not been wound up. And actually I'll add one more here, which is and VCFs who have investor complaints. Basically because SEBI has provided here and VCFs having at least one scheme which has not been wound up post expiry of its liquidation period, they have to make sure that they don't have any investor complaints. So those who have investor complaints also do not have the flexibility available to opt for migration. So they are also in the same boat. And anyway, if all your schemes are wound up, why would you migrate? And if you have made no investment, then again, no need to migrate. Such VCFs have to submit an application to SEBI to surrender their registration before 31st March 2025. So this is the hard stop deadline, failing which appropriate action shall be initiated to cancel their certificate of registration. The manager, trustee and KMP of the VCF or migrated VCF and the manager shall be responsible for compliance with this circular, with the provisions of this circular. The trustee or sponsor, as the case may be, shall ensure that the compliance test report prepared by the manager in terms of chapter 15 of the master circular includes compliance with the provisions of this circular. So you have to make sure that the CTR that you prepare annually has compliance with the provisions of the circular and responsibilities with the trustee, manager and the KMP. Circular comes forth with immediate effect and issued with the approval of competent authority. Now, I understand this is super complicated, that which VCF has to do what and how do you calculate the tenure. So to make your life easier, what I have done actually is that I have made a very helpful table for everybody who's kind enough to stick around till the end of this video. So if you look at the VCFs where all schemes whose liquidation period has not expired, definite tenure was disclosed in the PPM. The deadline is 19 July 2025. If definite tenure is not disclosed in the PPM, again same deadline. At least one scheme which has not been wound up post expiry of its liquidation period, this is the deadline. Only if no pending investor complaints. And all schemes have been wound up or no investment has been made by the schemes which are not wound up, you have to submit an application to SEBI for surrender of the registration before 31st March 2025. How will the tenure be calculated for AIF for VCFs where all schemes whose liquidation period has not expired? If your tenure was disclosed in the PPM, you continue with the same tenure upon migration. If it was disclosed, then you do this. If it was not disclosed, then the residual tenure of the schemes of the migrated VCS shall be determined with the approval of supermajority. And what if you do not migrate? Then you will be subject to enhanced regulatory reporting in line with the requirements of AIFs. If you are a VCF with at least one scheme which has not been wound up post expiry of liquidation period, your tenure is a one-time additional liquidation period is provided to you till 19 July 2025. And if you do not migrate, you will be subject to appropriate regulatory action for continuing beyond the original liquidation period. And for these schemes, there is no facility for migration. So I've tried to capture the entire circular in the form of one table. I hope you like this video and do check out my website called navigateaif.com, wherein I have a detailed course for the NISM Series 19C Alternative Investment Fund Managers exam. Thank you for watching.